giving you date. This intra-court appeal is filed against an order dated 4/1/2023, passed by learned single judge, by which
construction is post the date of undertaking. This is walking on thin ice. Kindly come to the next paragraph. Next one. The said contention of the petitioner is contrary to the record. And also the order dated 20.710. In the writ petition, there is no mention about the fact, and even while giving, there is no mention that the petitioner had completed the aforesaid construction. So the ground is that my undertaking did not contain details of what was the construction as on the date of the undertaking. And then the judge brings in the legal proposition on the basis of which he comes to the impugned conclusion. Your Lordship may see what it says. As discussed supra, in the order dated 2710, this court categorically held that the petitioner cannot.
We get it that without recording evidence, this finding could not have been recorded that after construction, after undertaking, whether you carried out any construction.
Well, yes, that is one. I am saying the learned single judge comes to the conclusion that the permission was cancelled. Therefore, I could not have made a construction because it's illegal construction. The construction could be illegal.
No, so what is your
contentious?
Your case is that 6/9/21 you have not made any construction.
6/9 I have not made any. And my lords, subject to what your lordships may say, I am willing to have a technical engineer appointed today to show that the construction laying on that property at the
What stage of construction on 6/9?
I filed the photographs which your lordships would find at page 136. From page 136, they are not the best of pictures to have, my lord, but these are the pictures filed. And this is the state of affairs. Your lordship may have a technical engineer to come examine and talk about the age of the construction because that is the story. And this is criminal proceedings. While I believe, my lords, that upholding the dignity of this court is paramount. And I have...
Where are the actual photographs? See, these are copies like blurred, this thing. Actual photographs.
They are filed, I'm told, in the file. They are in the file. Along with the writ petition. It is in the writ petition file. It's in the writ petition file. I don't think the file would have come to your notice.
Well, you could have annexed those photographs also, another copy here.
There's no date. There's no date of the photographs. Lordship may only notice.
Kindly come to page 137, my lord.
Wait.
Mr. Reddy, one thing only at this stage. What is the material to show that he has raised any construction after 6/9/21?
Please notice one thing in para 50, what the learned single judge says. He says, you make it deliberately vague. What is the stage of your construction as on the date?
No. So, see, Mr. One thing,
Yes.
broadly speaking, contempt there has to be a willful disobedience of the order, right?
In fact,
One minute.
Yes, I'm so sorry.
So, and as a quasi criminal proceeding, therefore, this thing. So, don't you think his stand is that he has not raised any construction after 6/9/23? 1 minute, listen to us, Mister. Please listen.
Please.
Then we are always, we can hear you.
Yeah.
So, his contention is that I have not done anything after 6/9/23. You say he has done it.
I'm not saying so. What I'm trying to say.
No. That's why he has violated the undertaking. That's why you have filed contempt,
Yes.
right? Against him.
Yes.
So your case in substance is that he has violated the undertaking and raised construction after 6/9/23, correct? How we don't want him to go scot-free. But before he is punished, this fact has to be established whether after 6/9/23 he has raised any construction. This you will agree.
First thing, my lords, if he gives such an undertaking, the affidavit filed with the writ petition must state, as has fallen from the bench right now, what was the stage of the construction on the date of the undertaking. In the writ petition, I should say, I have laid a slab in the writ petition. I will not conduct any further construction is what I would say. He doesn't say that. Further, my lords, the counter of
So,
the
Mr.
state.
But in that contempt, now that question ought to have been considered by the bench accepting the undertaking. And you should have pointed out that no, this way undertaking is vague. Please do not accept. One, 1 minute, the undertaking was accepted by the bench which dealt with the matter, right?
And they continue.
Now, Mr. Reddy, same thing, right? Please understand. It boils down to same thing, right? He is saying these facts of the matter is he is liable for contempt provided he has carried on construction after 6/9/23. Correct?
Yes.
And he says he has not done so. You say he has done it. Now, how to determine this fact? You tell us what means we can determine this.
That, my lords,
By an independent person, you tell us who can find out whether he has raised any construction after 6th of September 23. He has said, senior counsel has said that this age of construction and anything, any expert person, you tell who should be that expert.
One thing, I'm glad your lordships are asking that question. The order of the court was not based on my submission or his admission or anything like that. The municipal commissioner of Narsingi municipality, in the counter filed by him in the contempt petition, himself said there is a violation of that. They are continuing with construction. And himself says, I only demolished a part of the building, doesn't say why he demolished, why he did not demolish the whole. Then he files another counter manner. Just see the manner in which the municipality is saying. Now, municipality is an impartial body, my lord. We were both interested. Municipality said that the construction.
No, that's why we don't want you, we want an independent person. That's
Yes.
why we are asking municipalities also respondent in the rate petition.
Yes.
So we do not want parties involvement to this issue.
No.
You tell us who will decide, which independent body, Mr. Reddy, will decide this. Can decide.
I will just come to that question. Lordship may see only page 79.
No. So are you opposing that prayer? Do we take it that you are opposing that prayer of ascertaining this fact by an independent expert body?
But I have no one to oppose because it's a contempt appeal. The matter is between the contemptor and the
Ah.
court. I am only bringing a relevant fact before your lordship.
So we think like then if you have no locus, then we will pass an order. Who will do it, Mr.?
Because
You
when
are saying that you can't oppose, then will ask him. Before he goes to jail, we would like to satisfy ourselves that he has violated the order.
one small submission. The commissioner of municipality is a responsible authority. Page 79 is a sworn affidavit. At para 5, he says there has been a violation.
There is, Mr. This finding has not been recorded with reference to.
Very interesting.
He has.
Finding has not been recorded with reference to his stand by learned single judge because he says so.
No, he has done so.
Learned single judge said,
His lordship says.
no, where he has said that para 5 municipality has said, therefore I am holding that construction has taken place beyond 6/9/23. Please tell us
Yes.
which paragraph of the order.
Page 79 for a moment. Your
No,
lordship
order of learned single judge.
referring to that particular.
Yes.
It's not there, but lordship.
Not there. That's what we are saying, that you are, now you cannot like Mohinder Singh Gill sort of situation. No, you are trying to, that order is passed, then you are trying to supplement it by, no, they said here in para 6, that the learned single judge has not seen.
That is what I'm trying to submit.
It is not the basis of passing. We are not letting him go scot free.
And the
We are directing, you tell us, better you tell us which independent body can examine it and give us a report in a seal cover, an affidavit stating that whether or not construction has taken place on after 6/9/23.
well, it's
6/9/21.
HMDA
6/9/21.
21.
and several undertakings given thereafter, my lord. It's not one undertaking. Several undertakings are.
This order only refers to this
One.
6/9/23.
Yes, but several given.
Whatever.
Yes,
Punishment.
HMDA, my lord, this land falls. HMDA is a good authority, my lords, who may do so. That is my.
No, HMDA who not a clerk of HMDA.
Commissioner HMDA will be the appropriate
Well, may
authority.
I suggest?
Commissioner is what? IS officer?
May I
It
suggest?
should be an IS or conferred.
I
No,
have-
but he may not have the technical knowledge.
Some engineer from the GHMC or the HMDA. Your lordship may
You tell
Karsingi municipality, my lord, commissioner.
let it be outside of that municipality
outside the.
or that municipality.
Because finding is they have contact with each other, my lord.
No, that's why.
For the more reason, let justice appear to be
Sub
done.
independent body, no. GHMC is independent. You think it's independent?
May not speak both of this. We could have somebody from the JNTU, man. A professor,
Yeah.
JNTU.
GN. JNTU. So this JNTU,
Yes.
Jawaharlal Nehru Technical University.
Technology University.
And who will should be the person? HOD of Civil Engineering Department.
May I suggest this, my lord? So your lordship may say the HOD or a delegate on behalf of the HOD
Whatever.
To- inspect and submit a sealed report to the.
HOD. We will
The
request.
reason
HOD.
I tell your lordship,
We are
why
sure that if we ask HOD, he will do it.
that should not make a difference. I'll
Right, Mr. Reddy?
Or I'm submitting.
No, the all contentions are open, but we, as you said, that it's a matter between contemner and the court.
That's the
So
principle.
before, yes, of course, correct principle you have said.
Keep citing.
No, before sending him to jail, we want to be satisfied. See if this report comes against him. The order stands simple. This appeal under section 19 mark their presence. This appeal under section 19 of Contempt of Court Act 1971 has been filed against an order dated 4th of September 2023 by which the appellant has been found guilty of violating the undertaking dated 6/9/2021 furnished by him to the court, as well as order dated 27/1/2021 passed by learned single judge in WP number 13491/2021. The learned single judge has therefore directed the appellant to suffer imprisonment for a period of 6 months and to pay a fine of ₹2,000. Paragraph. We have heard learned senior counsel for the parties to some extent. Full stop. The dispute. Full stop. The issue whether or not the appellant has violated the undertaking furnished by him to the court on 6/9/2021 as well as the order dated 27/1/2021 in turn depends on the fact whether or not the appellant has carried on any construction in the premises after 6/9/2021. Full stop. The paragraph. The aforesaid pivotal issue needs to be adjudicated. Therefore, in order to ensure just and proper adjudication of the controversy, we direct that head of the department of Jawaharlal Nehru Technical University. We request you, don't direct. We request head of the department of Jawaharlal Technical University to visit what site? To visit.
Site located at.
You give number
We'll
particulars.
give the details. We'll give it to the
Details.
stenographer.
So and so,
Lordship will find it at page 1A.
whatever, you give it.
We'll
So
give
and so, because he may not know where to go. So and so place. The head of, needless to state that head of the department. You will remain present, right?
My lord.
The head of the department shall issue a notice to the parties for date of inspection and thereafter shall carry out the inspection. In the report it shall specifically be stated whether any construction has been carried out after 6/9/2021. The head of the department of JNTU is requested to submit his report in a sealed cover. head of the department along with a
Engineering.
along with a civil engineer, right? Head of the
He does it
department.
side, when they are talking to the citizens, in a sense, it need not be so harsh in a way that is suggesting that he's trying to threaten the petitioner, which cannot be accepted. I feel that it's better the contender comes before the court and answer the questions. He has a very long discussion, which is not supposed to do it. It is not within his jurisdiction.
Like
When he will appear, tell us.
your lordship may fix the date.
When?
But I will also file, your lordship, I'll also file a transcript of the conversation, what is taken
Yes.
also, blood.
Yes, please. We have, keep it here on this.
Morning, he was
Lordship, so extremely sorry, Millard. I'm sorry to
Take-
make a mention before your Lordship. It pertains to medical admission, one writ petition, Millard, kindly have it tomorrow. Petition number 25459 of
When have you
2020.
filed it?
Today morning, I have filed, Millard. Similar situated person has been considered, and I am also in the same group. Has
Tomorrow.
not been
Don't
considered.
argue now. If you are ready, we will, if Mr. Rao is not here,
Yes, I have already informed him, Millard, with
Tomorrow.
great respect to the sample.
tomorrow. Yes.
Obliged, Millard, deeply obliged.
Ah. Yes. Yes, madam.
May it please your lordships, and for the petitioner, my lords. My lords, this is a covered matter, my lords. The matter is pertaining to admissions of local and non-local candidates.
No, this is not covered, madam. Yesterday we have passed an order to this. Ah. So when were you treated as non-local candidate?
My lords, in the,
When were you treated as a non-local candidate? 2/8/23?
yes, my lord.
And you have filed the petition when?
Today, my lords.
Today?
Yes, my lords.
Today is what date? 11/9,
Yes,
12/9.
12/9.
Ah. What were you doing from 2/8 till 12/9? We have already held.
My lord, my-
Similar petitions have been dismissed, madam. You, yesterday, order, number. All right, anything else, madam? Similarly covered, right?
my lords, I'm a permanent resident, my lords, but I was marked as non-local in the merit list, my lords.
So therefore you are challenging the validity of rules, right?
Yes, my lord.
Now,
Yes.
fine, dismissed. That order is, where is madam? Yesterday we gave it to some madam, which person? Huh? So that paragraph and all that dismissed. All right, yes,
Much obliged.
no, 60, no, one case.
Wait, please. Wait, please. The writ petitions, there are two.
There are two petitions.
Yes. One by state of Telangana, another by the.
Which one is by state of Telangana? Acha, this is
What? Writ petition 37,555.
599.
Yes, 37,555, 37,559. And both challenge that exhibit T1 dated 29th August 2022. An order issued by the Government of India Ministry of Power purporting to exercise powers under Section 92 of the Andhra Pradesh Reorganization Act.
Order dated
29th August 2022. Page 37 of the state's writ petition.
So we take up this WP 37,555, right? You are appearing in 37.
37599 pleadings, my lords may kindly refer to.
All right, 37,
37559.
No.
Sorry, 588.
37599. Which page order dated 29/8/22?
Yeah, page 37,
30.
exhibit P1
All right.
is the order 29th August.
Asked under section 92.
Yes. Of the AP Reorganization Act. And whereas the order says, whereas AP Reorganization Act 2014 came into effect from 2/6/2014, whereas Schedule 12, Section 92 of the Andhra Pradesh Reorganization Act, inter alia provides as under existing power purchase agreements with respective DISCOMs shall continue for both ongoing and projects under construction. For a period of 10 years, successor state that has a deficit of electricity shall have the first right of refusal for the purchase of surplus power from the other successor state. Whereas Power System Operation Corporation, POSOCO, in its letter dated 18/6/2014, conveyed that during the meeting held on 28/3/2014, APSLDC shall continue supply of power according to schedule in force as on 2/6/2014. In accordance with the decision taken, AP Genco supplied power to TS DISCOMs. Therefore, AP Genco supplied power to TS DISCOM. Whereas AP Genco had supplied power to Telangana DISCOMs post bifurcation. From 2/6/2014 to 10/6/2017, there is some dispute in regard to the period, but broadly it is correct. Under clause C2 of Schedule 12 of AP Reorganization Act, so the issues related to power supply use. Representations have been received from state of Andhra Pradesh that Telangana has not paid for the power supplied to that state from 2/6/2014 to 10/6/2017. Whereas there is no dispute regarding the amount to be paid for the power dues, the principal amount being rupees 3,441.78 crores and late payment being rupees 3,315.14 crores to be paid in addition to the principal amount as per the applicable provisions. This factual statement is also incorrect. Every right of one party entails a corresponding duty. Right and duty are co-joined, and as such, Telangana must pay the power dues to Andhra Pradesh for electricity supplied to them under the orders of Government of India, issued under the Andhra Pradesh Reorganization Act 2014. Each one of these is incorrect. Supply was by AP Genco to Telangana DISCOM, not by the states. The states have no obligation. And Miller, it is not supplied under the orders of Government of India. It is supplied pursuant to Schedules 12, para C of the Reorganization Act. There was no order of the Government of India. Therefore, Government of India, in exercise of powers vested in it under Section 92 of the AP Reorganization Act, hereby orders that the successor state of Telangana shall pay the due amount, as mentioned in this order, the successor state of Andhra Pradesh, within a time frame of 30 days. The central government is obviously cognizant of the fact that the dispute as between Genco and DISCOM is not a matter which can be resolved by the Government of India at all. There are separate provisions under the Electricity Act. And in spite of that, it says it is a dispute between the two successor states. So one dispute between the two successor states is purported to be taken up and disposed of without taking into account the dues from state of Andhra Pradesh to state of Telangana. Various number of matters are pending. Now, this is the order which is under challenge. Now, I must indicate that a large number of petitions, other petitions filed by the Telangana corporations against the Genco are pending. There is an order of restraining order of the Telangana State Electricity Regulatory Commission restraining AP Genco from taking coercive steps for recovery, which has been challenged by them in a petition. No stay has been granted. That is not listed. That's not taken into account. There is a petition filed by state of Andhra Pradesh for comprehensive determination of the disputes in regard to sharing of assets and liabilities between the two states in the file in the Supreme Court in August 2022, in which notice has been issued, and the matter is directed now to be listed on November 2023. These are some of the other petitions which are pending, and reference to it, as I take my lords through the list of dates, I'll take my lord. But one single dispute putting to the payment to be made was supplied by the AP Genco to Telangana Discoms is taken out and treated as an interstate dispute, and power is sought to be exercised under Section 92, which power is not there. And the assumption, I have huge other claims that is not taken into account. Now, if my, yes, and my lord, this order, in my respectful submission, has been made, has been issued by the Government of India, though the matter was taken up in by the government in the committees set up for the purpose of resolving these issues, standing committee of the Southern Zonal Council in a number of meetings, and was to be taken up in a meeting to be held in 2022 September. Even before that meeting could take place, without hearing Telangana, though Telangana had been put on notice that we will be taking up this matter in the next zonal meeting, without hearing us, an order which seems to finally determine that issue has been issued on 29th August 2020. This is brought in short, Miller, the order. If I may place, Miller, the relevant list of dates. And list of us. December 2009, 3 power purchase agreements between Andhra Pradesh Power Generation Corporation and Andhra Pradesh Distribution Companies for 1/4/2006 to 31/3/2009. The relevant period comes within this. And Miller, this was at the time when the state, there was undivided state of Andhra Pradesh, but the agreement was between the generating companies and the distribution company. 22nd December 2009, composite PPA, Miller reference has been made where it appears. On 1st March 2014, Andhra Pradesh Reorganization Act received the assent of the President. 2nd June 2014 is the effective date on which Andhra Pradesh Reorganization Act started being implemented and state of Telangana came into existence. 2nd June 2014, Apex Committee, Power Coordination Committee was set up in accordance with the Andhra Pradesh Reorganization Act. On 16 June 2014, State of Andhra Pradesh unilaterally cancelled all the PPAs by letter dated of that date, 16 June, from AP Genco to Telangana distribution companies. 17 June 2014, letter by Government of Andhra Pradesh Energy, Secretary Energy, to Chairman and Managing Director AP Transport to schedule power in 65:35 ratio from projects located in AP. Additionally, the rescission of PPA did not have APERC approval. On 18 June 2014, which is a communication referred to in the order, impugned order, letter by POSACO to APSLDC conveying that APSLDC shall continue with the supply of power as per the existing scheduling procedure as per Andhra Pradesh Reorganization Act. 24 June 2014, meeting of Southern Regional Power Committee at Bangalore. where all participants except AP Transco agreed that scheduling of power from AP Genco, AP, Andhra Pradesh should continue as per Andhra Pradesh Reorganization Act. 11th August 2014, Common Order of Andhra Pradesh Electricity Regulatory Commission in OP numbers 14 to 25, directing State of Andhra Pradesh that withdrawal of PPAs is not valid and the PPAs cannot be unilaterally rescinded by AP Genco. At the appropriate stage, I will place relevant portions of this order. Telangana, 15 June 2014 to 31/5/2015. Telangana Discom floated tenders for short-term procurement of power for this period, as State of Andhra Pradesh did not schedule power from Krishnapatnam Power Plant. 11th August 2014 to 11th June 2017, despite Andhra Pradesh Electricity Regulatory Commission order dated 11/8/2014 and state load dispatch centers directions dated 18/6/2014, State of Andhra Pradesh did not supply power to state of Telangana. They supplied some power, but not fully. And that I have set out. State of Andhra Pradesh did not supply 805.66 megawatt from Hydel Station, 862.24 megawatt from Krishnapatnam Thermal Power Plant, 560.5 megawatt from Hinduja Thermal Power Plant, from Srisailam Right Bank from 11/6/14, from Upper Sileru from 23/6/2014, from Interstate Hydro Project from 2017, from Machkund Dam from 2017, from Tungabhadra Dam from 2017, and thermal station. Due to this, Telangana Discom had to purchase electricity from the market at a very high cost and incurred an extra cost of rupees 7,354 crore, including interest. On 4th January 2016, letter from PTC India, that some of these may not be very relevant, therefore may skip these. In regard to our having to purchase from other states and etc. That for the time being, I don't think it's very relevant. I will skip these and go straight away to the next page. Kindly come to 2018, middle of the page. AP Power Utilities filed company petition so-and-so in the NCLT for recovery of dues in regard to the power supplies and the bills that had been raised. This is withdrawn subsequently. Therefore, one means of recovery they adopted was by filing a company petition in the NCLT on the basis that we have not made the payment in regard to admitted dues. This was withdrawn by them. Then next, Telangana Discom filed OP number 59 of 2018 before Telangana State Electricity Regulatory Commission, and the Telangana State Electricity Regulatory Commission was pleased to direct the AP Power Utilities to not take any coercive measures against Telangana State Discom. This order, unfortunately, is not on record, but I got copies. I shall place them. There is after hearing the Andhra Pradesh Power Utilities, an order is passed restraining them. This order is challenged by the AP Power Utilities before the Honorable High Court, this Honorable Court at that time, it was one single court, Writ Petition 42577 of 2018. This, I believe, has been transferred to the Andhra Pradesh High Court and it is pending. Although, according to me, that transfer will be wrong because it challenges the order of the Telangana State Electricity Regulatory Commission and the petition had been filed by the Telangana Discom. So, at that transfer, I think perhaps as and when the matter comes up before the AP High Court, they may retransfer it because that is what has been happening. But it is still pending. No interim order is granted. So the order of the State Electricity Regulatory Commission restraining the AP Power Utilities, including AP Genco, from taking any coercive steps for recovery in respect of dues on the power supplied by Genco to Telangana, AP Genco to Telangana Discom is in force till date. In spite of that, they have gone ahead and moved the government of India as if it is a dispute between the two states. Now, and government of India is the counter affidavit and the Genco, AP Genco in the counter affidavit says, no, this has nothing to do with the sharing of assets and liabilities between the two states. It is only in regard to supply of power dues, in which case there is a direct order restraining you from recovering. In spite of that, this is not even taken into account. Now, Telangana, 19th August 2019,
This order you have, Mr. Vaidyanathan, this
yes, I have.
restraining them from.
Yes, OP 59 of 2018, I have the copies. Can you pass? Yes. I've got two of those. Yes. My lords, para 1 sets out the prayers made and the facts are set out. Para 9, amidst the applicant stated that even after 4 years since the formation of state of Telangana, various issues including sharing of assets and liabilities and sharing of employees between power utilities in the residuary state of Andhra Pradesh and state of Telangana are not yet finalized and waiting for adjudication before various legal forum committees. Amidst these disputes between the power utilities of state of Andhra Pradesh and Telangana, AP Genco raised bills on Telangana discounts basing on generation tariff issued by present APRC on 26/3/2016 for the power supplied by the power plants of AP Genco to Telangana discom. Initially, AP Genco raised bills based on power sharing ratio proposed in TOMS number 85/2004, intentionally ignoring the actual schedule of power to applicant. This was objected to and requested respondent number 1 in this petition to bill only for actual generation. Applicant stated that without prejudice, any prejudice to prevailing dispute in respect of play, Telangana discoms have paid rupees 3,886 crore to AP Genco on provisional basis, subject to reconciliation and settlement of dues at state level. Considering the fact that all these power utilities, that is AP Genco, TS Genco, AP Transco, TS Transco, are owned by respective governments of residuary state of Andhra Pradesh and state of Telangana. It is stated that AP Genco is insisting that the claims of AP Genco for the power supplied by them to Telangana discounts till October 2017 may be paid after netting of the power purchase claim of TS Genco against AP discount for the power supplied by power plant under Telangana Genco to AP discount. Applicant stated cleverly sidelining the final claims to be settled among all the power utilities at state level between two successor states in accordance with the provisions of Settle Act 6 of 2014. Then those are set out. And then will kindly now come to para 16 refers to various disputes pending, dues payable by AP Genco. Those are set out 1,391 crore, 3,096 crores, and para 17, 2,137 crores. These are all amounts which are pending. And para 19 refers to national NCLT proceedings, which was moved. And then kindly come to para 24. Applicants petitioners have sought the following reliefs to cause necessary interim direction to AP Genco not to proceed with any coercive measure before any other forum in respect of the alleged claim to be paid by Telangana Discom, that is a petitioner, until the main petition is disposed of by the commission. And Miller, under the Electricity Act, any dispute between a generation company and Discom, Miller, the Electricity Regulatory Commission has the jurisdiction. Respondents have not filed any counter affidavit either in the original petition or this interlocutory application. I have heard the counsel for the petition and perused the material on record. Though the counsel for the respondent did cause appearance on their behalf, yet did not make any submissions in this matter. In this regard, record of proceedings as recorded by the commission is reproduced. The council time was taken for counter, but nothing was filed. Those are all recorded. Proceedings are recorded. Then paragraph 27, even on the last date of hearing, that is on 112, no counter affidavit is filed, but time is sought for filing counter affidavit. Have to trace out the record pertaining to long old period, and for that they need sufficient time. Prima facie, on the basis of the above position as obtained in the matter, question that arises for consideration is whether there is a balance of convenience in favor of applicants for interim order, and if so, to what extent. Commission is empowered to pass such orders as may be appropriate under section 94(2) of the Act of 2003. In this case, applicants are seeking interim direction not to take coercive action by respondent number 1 in proceeding with any litigation before any forum till this commission decides the dispute raised by them under section 83. This commission is of the view that prima facie a dispute between a generator and it should be a generator and a discom is amenable to its jurisdiction as provided in Act 2003 and as upheld by judgments of courts of law. Moreover, applicants of the licensees of this commission are required to undertake power supply in the state of Telangana. Any hindrance to discharge of this function of the applicants would not be in the interest of the public at large. Therefore, the balance of convenience lies in favor of the applicant. Commission is also of the the actions of the respondents, more particularly respondent number 1, if allowed to be proceeded with, may cause not only cause severe damage to the interests of the applicant, but also are contrary to law and provisions of the statute. No prejudice will be caused by respondents if the actions of respondents are stopped pending disposal of the petition. As such, actions can be proceeded with after disposal of this petition. Moreover, respondents have not chosen to state their case by filing a proper counter affidavit as to why interim relief shall not be given to the applicant. In these circumstances, and for the reasons recorded therein, exercising the power conferred on the Commission under Section 94(2), respondents, more particularly, respondent number 1 is restrained from any coercive action before any forum till this Commission decides the original petition, the larger public interest in progress. And it is in regard to the very same use up till October 2017. This order was challenged by the AP Genco. The response here, my lords may see in the petition, Andhra Pradesh Power Generation Corporation, which has supplied the power, and the petitioners are the discoms, Telangana discoms. And though this was challenged, no interim order was passed by this honorable court or after transfer by the Andhra Pradesh High Court. And the matter is still pending. And the OP 59 of 2018 is also still pending. So the very subject matter of the dispute in regard to the dues in respect of power supplied by Genco is the subject matter of our competent proceedings before the Electricity Regulatory Commission, which has not yet been disposed of, and there is an interim order. And this is not even taken note of by the government of India. I'll place the relevant proceeding. Now, I have already placed the order that doesn't take note of this. Now, if I come back to the list of dates, this is again interesting. Very, 19th August 2019, Telangana and Andhra Pradesh power utilities signed a reconciliation statement for all power utilities of both states that all power utilities issues will be settled at state level. AP Genco has been insisting on settling merely power purchase dues while completely ignoring other power utilities due to state of Telangana, such as debt servicing, etc. Now, this is also very relevant. May I place straight away, if my lords will kindly have a look at page 170 of the paperwork, a writ petition. Minutes of the meeting. Dated 19th August 2019. And AP Energy Secretary is there, Chairman AP Genco, Chairman AP Transco, all of them are there. Similarly, Telangana side, Special Chief Secretary, Government of Telangana, CMD, the Genco, etc. are there. Kindly now see, what is all the disputed issues between the power utilities of both the states were discussed and the decisions taken are indicated in the annexure. And kindly now see the annexure. Annexure to, I'm sorry, it is in the reverse. Annexure to the minutes of meeting dated 19th August 2019, issues between AP and Telangana state power sectors. Power bills, decision taken, both agreed, and amount due by AP 8,199 crore, by Telangana state 11,641 crore. Interest on sales of power due to AP Genco agreed to pay on net amount yet to be resolved 604.7 crore. Demerger adjustment account on account of mismatch of assets and liabilities issued to be referred to C&AGs for opinion. Amount is indicated. Interest overdue on FRP discount bonds after employee bifurcation. Like that, some of these items are deferred. Some agreed upon interstate sales, reactive charge claims, energy charges, various things. And as what is agreed in this meeting is 10,160 crore is due by Andhra Pradesh. 12,648.76 crore is due from Telangana utilities, and this yet to be resolved 4,609 crore, of which the main thing is in regard to employee bifurcation. As my lords may see, the items are 1180 crores investment of pension trust and 125 crore, 150.
Where,
etc.
which employees, which entry is
Yes.
this?
Well, it is in the last column yet to be resolved. The items are kindly similar from 4 to 4, 6, 7, 8. These are yet to be resolved. And these amounts now the employee bifurcation has been done, completed. Therefore, this was to be done after employee bifurcation. That is also completed. Therefore, these amounts also will have a substantial part is due to Telangana. We have given a subsequent comparison as to how much money is due. About 20,000 crore is due from Andhra Pradesh, which we have indicated. These amounts still pending. This was what was agreed upon in 2019. And today, both sides want. In fact, when the petition filed by Andhra Pradesh, which was for distribution of assets and liabilities division, a consolidated petition, the government of India had appeared through the learned additional solicitor general, Ms. Aishwarya Pati had appeared, I think, at that stage. And they had not filed the counter affidavit. So one of the suggestions that was said was, why not try to resolve? Because government of India ministry should resolve. If they are not able to do, send it for mediation to some retired Supreme Court judge was one of the suggestions which Government of India said will consider. So the matter stands posted to November. Now, this writ petition is filed by them 10 days before the order is issued by the Government of India. What compulsions were there? There are various things that take place on the floor of the Parliament and elsewhere, to which we can't take note of, and I don't want to draw reference to that. But whatever it is, some compulsions because of which this order can be issued. Though substantial amounts, which I will, when I deal with the, come to the relevant date, I will point out. Now, to come back to the list of date.
So where is that order, you said that between the two state governments, there is
Yes.
an order saying that it should be referred to a farmer supreme.
What has, that's not been recorded in so many words.
Okay.
Yes. Now, please see, please have a look at the. Yes. Look at the petition copy and the order. Last time. Yes. Order date 4th August 2023. In fact, the SG was to appear. SG could not be present, but Mr. Natarajan had appeared. Yes. You got the copy. It's 4th August. Kindly have it. Kindly give to the government. One more copy. 25th copy. Yeah, I'll give the copy. This was on 4th August. Reply has been filed on behalf of respondent number 2, State of Telangana. Learned Counsel for respondent number 1, Union of India, prays for and is granted 3 weeks time from today to file counter reply. Rejoined affidavit, if any, may be filed within 3 weeks after service of counter affidavit reply. Relist in the month of November 2023. And the suggestion came, one of the prayers in the petition itself is for a reference of the disputes to arbitration or mediation. That was that prayer. We have copied this petition policy. Last time we had taken. Yes, please. That's all. Kindly have a look at the prayers, Miller. Para 10. Non-apportionment of assets has led to multitude of issues adversely affecting and violating the fundamental and other constitutional rights of people of state of Andhra Pradesh, including employees of the said institution. Without adequate funding and actual division of assets in terms of apportionment made under the Act, functioning of the said institution, state of Andhra Pradesh has been severely stunted. Post-bifurcation, Hyderabad was the capital, not only transformed into an economic powerhouse, etc., etc. Then, please come to next page. Approximate value of assets of headquarters of Schedule 9 institution is estimated at 24,000 crore. In respect of Schedule 10 institution, total approximate value of fixed assets to be divided between two successive 34,000. Well, all this on the basis of real estate value. Whereas Act says, headquarters will be given to respective wherever where it falls, and there will not be distribution and valuation on this basis. Whatever it is. Now, what is important is kindly see, it refers to various committees which have gone into this. Sheila Bide Committee, Para 22, Para 24, Dispute Resolution Committee, with the Union Home Secretary as the chairman of field secretaries of both the states. And as chairman and chief secretary of both states as members, this committee has held several meetings, including meetings held on so and so. All those dates are mentioned. And Millard, reference under section 66. Then the disputes which are pending, para 28 Andhra Pradesh Bhavan. Then para 38. Millard, reference made to another petition pending. Then AP State Council of Higher Education, where Supreme Court Justice Gopal Gowda had disposed of the matter and sharing how it is to be done. Telugu Academy, Dairy Development Cooperative Federation, Mineral Development Corporation, then request for arbitration, and then the grounds, and then kindly now come to asset, the page 29, what are to be shared, page 28 bottom, in terms of the assets, four distinct categories: assets movable and immovable belonging to the state, assets movable and immovable belonging to organizations, corporations mentioned in Schedule 9, and the GENCO and TRANSCO are entities mentioned in Schedule 9. Organizations, corporations mentioned in Schedule 9. Both GENCO and TRANSCO are mentioned in Schedule 9. Assets movable and immovable belong to organizations mentioned in Schedule 10. Assets movable and immovable belong to organizations not mentioned either in Schedule 9 or Schedule 10. Assets belonging to the state, those are set out, Millard. Then the institutions. And then the prayer at page 37. Prayer. Declaring, page 38, declaring the inaction of the state of Telangana and Union of India in not dividing the assets and liabilities of erstwhile state of Andhra Pradesh, including assets and liabilities of institutions specified in Schedule 9 and Schedule 10, as also other institutions between two successive.
Para 539.
Yes, that is.
Appointed.
Yes, that's right. Appointed impartial, neutral, and independent arbitrator of the to supervise and monitor the actual division of assets and liabilities. In fact, some such names were also suggested at that time, at some stage.
All right. So,
This is
what are your submissions, Mr. Broadly, if we can note down?
Yes,
Submissions.
if I have a note where in 2 pages I have crystallized, that will be easier, if I may give that note. My copy. No. Yeah. Yeah. A 2-page overview.
This thing,
I have a copy.
is only reference to this Schedule 9. Schedule 9. If we say that there was a dispute and Schedule 9. And the two other issues. The issue of power sharing is not there in the issue carries in the.
I have to complete the list of dates, but
Yes.
I will first break
Sure.
the give a broad overview and then go to the list.
You can complete the list of dates
Yes.
then.
Right.
Ah.
I'm grateful. I'm grateful. When I was on,
19th
Right.
August.
that's right. 19th August 2019, I had shown.
Hmm.
In 2021, Andhra Pradesh Power Utilities filed writ petition 21638 of 2021 before this Honorable High Court against State of Telangana for payment of post-bifurcation dues. This is the same amount in regard to supply. Then, in regard to the very same dues for supply of power, they filed a writ petition. This was withdrawn on 9 June 2022. They filed NCLT petition in NCLT, withdrawn. They filed a petition, writ petition in this honorable court, withdrawn. He had got an interim order restraining them. They have filed a writ petition challenging that. That is still pending. There is no say. Now, then 2021-22, Andhra Pradesh requested Ministry of Power, Ministry of Home Affairs, Government of India for intervention to get their power purchase used. Now, though they have been restrained from moving any, they say that we will now move the Government of India. During various meetings, State of Telangana represented that all bifurcation related issues to be taken up together rather than only power purchase use as requested by Andhra Pradesh. Letters from State of Telangana to Government of India regarding pending dues payable by State of Telangana from State of Andhra Pradesh. Breakup of total receivable by State of Telangana payable by AP Power Utilities to Telangana State Power Utilities, showing Telangana has to receive 12,940 crores from Andhra Pradesh after directing money that has to be paid to AP Genco for power purchase by Telangana State Power. Now, if they file a civil suit or any other claim, I will be entitled to get a set of the Telangana Power Utilities, and if I set it off, after deducting all that, they owe me 12,940 crores. This is not taken into account by the Government of India, and I will show from the notes which have been made available that somebody records in the noting file that State of Telangana has not produced proof in regard to these documents, in regard to these claims. Extraordinary. But did you even give me an opportunity for all this? With great respect, the way they have gone about it's something which is shocking. Telangana Genco filed writ petition.
So you are not this thing put on notice before this.
No, please see, that's why I want to take my lords through the list of dates. Because they said we will take it up in the committee in September. 3rd September. The order is issued on 29th August without even hearing me. When I was put on notice that this is a matter which will be taken up by the committee on 3rd September. Well, please now see, therefore we had to, since our monies were not being paid, we filed petitions which are all pending, and they have not been listed today. In fact, I had made the request that they should be taken up together. Of course, my learned friend appearing for the AP Genco opposes that. But please see, these are pending. But Genco, Telangana Genco filed petition 25240 to pay application dues amounting to 4,774 crores to State of Telangana. This petition is pending and it's subject. Telangana State Power Distribution Company filed a petition 25788 to pay post-bifurcation dues amounting to 11,324 crores to State of Telangana. This petition is pending. All these are pending in this honorable court. TS Transco filed a petition 34824 of 2022 to pay employees' trust funds and other dues to State of Telangana. This petition is pending and is sub judice. And in none of these, counter affidavits have been filed. There is no answer. These amounts are due, but nothing is they don't want to file a counter of it or have the matter taken. Now, I will take my loss through the file notings in regard to what takes place, but I will, I have referred to it. Now, please see 8/2/22, Office Memorandum and Meeting Notes to the Government of India, Ministry of Home Affairs, providing that meeting will be conducted practically resolving issues arising from Andhra Pradesh Reorganization Act. Meeting of Dispute Resolution Subcommittee scheduled for 17 February 2022. Then the Ministry of Law and Justice seeks opinion. Their opinion is sought. It was replied that the matter is sub judice, governed by bilateral agreement, and Government of India recommends amicable solution. It was also noted that State of Telangana has claimed amounts for post-bifurcation dues. AP Genco has already filed a case before Telangana High Court. Matter is referred to Solicitor General. Solicitor General says when the matter is pending in the High Court, no directions can be given. That is on 12th March 2022. Since the matter is sub judice, it's not appropriate for central government to issue direction. 15th March opinion given by so-and-so, then 28th May, I shall be placing these meetings minutes, which are important. 12th Standing Committee of Southern Zonal Council, committee decided to keep the item of post-bifurcation power utilities dues for discussion in 30th South Zonal Council meeting, which was to be held on 3rd September 2022. This is a very important document. Kindly have a look at that. Page 158. Page 158 of the petition. Right. Kindly similar how they have been discussing various items and resolving. Items discussed in the 12th Standing Committee of Southern Zonal Council held on 28th May 2022 at Thiruvananthapuram. In the 29th Southern Zonal Council meeting held on 14/11/2021 at Tirupati, under the chairmanship of Honorable Home Minister Shri Amit Shah, discussions were taken up on 45 items, out of which 19 were resolved, and 26 items have been carried forward for discussion in the Standing Committee. Further, 63 fresh items have been listed for inclusion in the agenda for the 30th South Zone Standing Committee meeting. The carried forward items were categorized under Part 1 and fresh items under Part 2 for discussion in the 12th Standing Committee of Southern Zonal Council. Out of the 26 old carried forward items, 10 related to Government of Telangana and action to taken reports were submitted to Standing Committee, and item-wise deliberations were held on 28th May 2022 in the Standing Committee and are noted under Part 1, Agenda Item 8. Dues of 6,015 crores to be paid by power utilities of Telangana to Andhra Pradesh towards the cost of power supplied by Andhra Pradesh after the state bifurcation. Very same issue. Government of Telangana informed the committee that there are many demerger related issues between AP and Telangana power utilities which have to be settled. And once all these issues are settled, the post-merger of AP Genco dues will also be squared up. In fact, Telangana power utilities have to get around rupees 17,828 crores from AP power utilities. And after setting up the dues payable to AP power utilities, Telangana Genco has to get 12,940 crores. Government of Telangana has also brought to the notice of the committee about the transfer of share of Telangana amounting to rupees 2,884 crore in the employees trust funds, pension, gratuity, EL encashment, TF and gratuity still being maintained by AP Genco and AP Transco. They have the money, they have to give us. The committee was further informed about the discussions on the issue before the Dispute Resolution Subcommittee meeting held on 17th February 2022, wherein the Joint Secretary suggested that after getting the views of Ministry of Law, Ministry of Power may communicate the same to both governments and Ministry of Home Affairs for the comment. Action will be taken on the issue based on the comment of both the state government and the opinion of Ministry of Power thereof. And this opportunity was not given. As per the opinion of Ministry of Law and Justice, Department of Legal Affairs, Government of India, Section 92 confers on Government of India unambiguous powers to issue directions to the State of Government of Telangana for payment to State of Andhra Pradesh. This, in my respectful submission, is an incorrect understanding. Since the matter is sub judice before the court of law, it would not be appropriate for Government of India to issue such direction under Section 92. Energy Secretary, Government of Andhra Pradesh, in letter dated 19th May 2022, addressed the Ministry of Power that AP Genco has decided to withdraw red petition 21638 and requested to issue direction. But there are other petitions filed by us which are pending. They may withdraw the red petition, but our red petitions claiming money from them is still pending. Committee has decided to keep the item for discussion in 30th South Zonal Committee meeting during August 2022, which actually when it takes place on 3rd September, that notice is given. Yes. 64. Kindly similar page 164. From the Secretary, Interstate Council Secretariat, Ministry of Home Affairs, Government of India, dated 4th August 2022. The approved address to the Chief Secretary, Government of Telangana, the approved minutes of the 12th meeting of the Standing Committee of the Southern Zonal Council held on 28 May 2022 at Tirunelveli have been forwarded by the Secretariat on 3rd August. As you are aware, the 30th meeting of South Zone Committee is scheduled to be held at Tirunelveli on 3rd September 2022. In this regard, I would like to mention that the retained issues from the 12th meeting of Standing Committee on 28 May 2022 would be included in the agenda of the forthcoming 30th meeting of South Zonal Committee. It is requested that the updated position of such issues may kindly be sent to the Secretariat at the earliest and in any case latest by 18th August, so as to enable the Secretariat to finalize the agenda. And this is one of the items which had been kept back, being taken up in the 30th meeting. In this context, I would like to mention several of the issues were treated as solved or dropped, etc. And then kindly see the items, pending items, page 165. Agenda item number 8, page 165. Dues of item 8, say agenda item 8. Dues of rupees 6,015 crores to be paid by power utilities of Telangana to Andhra Pradesh towards the cost of power supplied by AP after state bifurcation, sponsored by Government of Andhra Pradesh. That is there, this one. And the details are set out at page 166. Dues of rupees 6,015 crores to be paid by power utilities of Telangana to AP towards cost of power supplied by AP after state bifurcation. Secretary ISCS informed that the issues is regarding so-and-so. And at the end of that paragraph, in the 29th meeting, it was decided that Union Home Secretary will call a meeting to resolve the issue. Nothing was done. Union Home Secretary did not call a meeting. It was not taken up in the Southern Zonal Council meeting of 30th, but even without all this, an order is issued. It was also brought to the notice in the meeting that a committee constituted by Ministry of Home Affairs on dispute resolution had discussed the matter with representatives of Government of Andhra Pradesh and Telangana. On the recommendations of the committee, Matter was referred to Law Ministry by the Ministry of Power. And Law Ministry has conveyed its opinion to Ministry of Power, according to which, since the matter is subject before court of law, and during pendency of dispute between Andhra Pradesh and Telangana in Telangana High Court, it will not be appropriate for the Government of India to issue any direction. It is also mentioned that Government of AP has informed that AP Genco has decided to withdraw the writ petition from High Court, and they requested Government of India to issue direction in the matter. Representative of Government of Andhra Pradesh intimated that the Energy Secretary of the state has already sent letter informing the updated status to Ministry of Power. Representative of Ministry of Power stated that the ministry will take appropriate action once the letter of withdrawal of case by Government of AP is received. In this context, Special Chief Secretary Government of Telangana requested that they should also be heard in the matter, and the Energy Secretary of the state had sent communication regarding this. That is, they have, AP says they have withdrawn. Then we say no, but we should be heard before you take any decision. Standing committee, then what the standing committee decided, treated the item as pending with the advice that AP will share the letter with the Ministry of Power, and also the Telangana's views to be heard at that time when the Government of India gives direction in this matter. Standing committee headed by the Honorable Minister, Mr. Shah, takes a decision that Telangana's views will be heard at the time when Government of India gives direction in the matter. We were not heard. No such hearing took place. Neither the secretary nor the committee heard Telangana and have unilaterally issued this order. And therefore, this is one of our principal grievances. We should have been heard. Now, my lord, if I come back to the list of dates, (9/6) order of this honorable court allowing the petition to be withdrawn. And there is one more petition ordered by so-and-so against AP Genco for payment of dues by AP to Telangana, notice issued by this honorable court. Then meeting of dispute resolution committee, then 1722 meeting notice, Ministry of Home Affairs, which I have already read. File noting. Now, my lord, I will take my lords now through the file notice before I make submissions on this. Then, my lord, kindly come to the next page. 19th August, writ petition 1091 of 2022, filed before the Honorable Supreme Court of India by State of Andhra Pradesh against Union of India and State of Telangana for payment of post-bifurcation dues, which I have already placed. 19th, same date, 19th August, letter from Deputy Secretary Energy Telangana to Chairman MD to transport to furnish latest update on the issue for 30th Southern Zonal Committee, which we give. Then on 9th, same day, a further opinion which had been sought from the learned solicitor is provided that despite there being no stay, any lawful action will be subject to final outcome of legal proceedings as well as subject to challenge by the aggrieved party. I'll place the Solicitor General's opinion. Since now the writ petition has been withdrawn, an order might be issued, that of course will be subject to final orders of the court. File noting by ministry, taking note of the further clarificatory opinion. Then 26th August, after this opinion is received on 24th August by the ministry, file noting by section officer, Ministry of Power, providing a draft order on the basis of it there is no legal impediment on Union of India. So 29th August, impugned order is issued. Not taking note of the fact that a meeting is to be held on 3rd September. It had been to take in the consultative committee meeting presided over by, chaired by the Minister for Home Affairs. A decision had been taken that State of Telangana will be heard before any decision is taken. None of this is brought to the notice. Minister of Power says, yes, this order may issue, and the Ministry of Power has issued the order. Ministry of Home Affairs is not kept in the picture at all in regard to this, though Ministry of Home Affairs has taken a decision, we'll be heard. Then, Millard, we have made representation, we filed petitions, etc. Now,